Hello, this is Mark DiCarlo, Voices of the Coastal Bend. Mr. Mark Skurka is my guest, District Attorney for Nueces County, Texas. How long you been District Attorney now?
5 years.
You having fun?
Yeah, it's fun sometimes. Sometimes it's not so much fun, but it's a lot of work and a lot of pressure, but it's really rewarding to help people too.
When is it? I would imagine it's not fun when there's a lot of maybe politics or people preventing you from doing your job somehow unethically. Is that when you say it's not fun?
I say it's not fun when you have to deal with outside influence. I try to keep politics out of the office. I think that is a nonpartisan office. What the district attorney's office is out there is to protect the community, whether you're Republican, Democrat, Libertarian, whatever it is. And we're there to help protect the community by putting the criminals away. And that's our main job. Our also main job is to give justice to the community. And that just means not sending everybody to prison, giving people breaks on first-time offenders, where I've got some programs in that way. But it keeps you busy, all balancing and juggling all the stuff.
Well, when you say politics comes into it, are you talking about political? Like you're a Democrat, you've been running as a Democrat. Are you saying is people who know people that you know, or are you saying political parties getting involved, or what are you stating?
I just think people try to go behind the scenes and create unrest, and sometimes try to make it into a political thing. But as a prosecutor, we're supposed to look at the facts. We're supposed to look at the law and follow that. It really doesn't matter what people sometimes, and of course the public has ideas about certain big cases and stuff, but they don't always know the inside information that we know at the district attorney's office, and we're prevented ethically from discussing. So
up to what point? Like there was a big case, I'm interrupting you, I'm sorry. There was a big case that regarding Benjamin Mustafa's killer, where he was given, I think just yesterday, he was given life, I believe, instead of the death sentence. At what point can you discuss a case? Do you have to wait to see if the case is there's a judgment of conviction or an acquittal, or do you have to wait until the resolution of an appeal? When, like in that specific case, could you talk about it now?
No, I can now because the trial is over. I don't know if he's going to serve notice of appeal or not, but I can talk about that now. And yes, that was a long, drawn-out case. It took about 5 or 6 weeks. We started on May 6th, and it took about 2.5 weeks to pick a jury, and then the trial itself took almost a full 2 weeks.
And this was, again, a murder, alleged murder, but I guess he was convicted.
You don't have to say alleged anymore. He was convicted of capital murder, actually.
Capital murder. And wasn't there an unusual proceeding? I seldom follow other cases because I try to concentrate on my own, and I don't want to get distracted because I do criminal law. But didn't they plead guilty to the capital murder or something? No, it was guilt and innocence?
He pled not guilty, so it was both a guilt phase and a punishment phase.
Okay. And years ago, they used to consider it, a gossip, whatever. If the state asked for the death sentence and they didn't receive the death sentence, some of the attorneys used to think that was a victory for the defense. So is that what happened in this case? Did you ask for the death sentence for the murderer of Benjamin Mustafa?
Yes.
But he got life.
He did.
And on that, why do you believe, was it the jury gave him life? Why do you believe, what were the major factors that you believe made the jurors give the murderer of Benjamin Mustafa, whose name I don't know, because again, this show is kind of a rock and roll party. We don't always know what we're going to discuss. Why do you believe the jurors gave him life? And what is his name?
Mustafa Bighamian.
No, not Mustafa's name, but the...
Daniel Garcia was the defendant's name.
Daniel Garcia was the defendant's. Why do you believe the jurors of Nueces County gave him life instead of the death sentence?
Well, I never got to talk to the jurors afterwards. They were dismissed after, so I didn't do it. I can only assume several things. And number one, remember, capital murder is murder plus something else. It's murder, in this case, plus a robbery.
Right.
It was during the commission of a robbery. That makes him eligible for the death penalty. It doesn't mean he automatically gets the death penalty. It just puts him in that category of very few crimes that you can be eligible for the death penalty. And there's two choices. There's death or life in prison without parole. That's another change that's only been around for a few years. It used to be life in prison, and people could get out after 20, 30 years or something. Well, now it's technically life without parole. So what happens and after he was found guilty of capital murder, and he was trying to get a lesser included offense of murder. The jury did reject that and just went with capital murder. Then there's two questions the jury has to answer. The first question is he a future danger? Is it probable that he could commit other crimes of violence and be a continuing threat to society? They actually answered that question yes, that he was a continuing threat to society. I was able to bring the jury about 10 or 12 convictions this man had. He had already been convicted 3 times of felonies, been to prison, had 7 misdemeanors. He committed 2 other assaults, felony assaults, while he was in the jail. He broke a man's jaw and gave him a concussion and then beat up another guy with his cane. He was a gang member too. He was also a self-admitted drug dealer. So all that stuff showed that he was a continuing threat to society, and the jury did agree with that. When it came to the second question, that's a question called mitigating circumstances. Mitigating circumstances are anything that could lower or make less severe the sentence. In other words, he did the crime, but does this guy have any redeeming qualities or other special circumstance that warrant he gets life instead of death? In that case, the defense did a good job of putting on some evidence of his background. It turns out that when he was very young, his mother tried to drown him to keep him from screaming and crying. It turned out that his mother was never at home because she had to work 2 jobs to support the family. It turned out his father was never at home. He had been in and out of prison several times. It turned out he went through life a lot without supervision. He was introduced to drugs by his sister when he was 14 years old. He had a continuing drug problem. He had a learning disability. One of the psychologists testified he had a learning disability and possibly undiagnosed ADHD. All those things the defense brought out as mitigating factors. Well, what the jury did was basically deadlock 6-6. Some people thought that was enough mitigating factors to warrant to get a license, and some thought not. So whenever you have a deadlock of 6-6, and of course it's got to be unanimous, it becomes, if they can't answer the question, an automatic life sentence. So I can only take from that the jury went with the defense's version of events, not that he didn't kill the person, but because of his troubled background. In fact, I think the psychologist called it a dysfunctional, chaotic background, his learning disability, his possible brain damage from that near drowning incident, his years and years of drug use, his low IQ were possibly mitigating circumstances, plus his youth. He was only 26 years old.
Do you think the jury considered the fact that, God rest his soul, Mustafa Bighamian went for the gun?
I don't really know what the jury, again, because I didn't discuss it with him, but it was very clear that Mustafa Bighamian had a gun and believed in self-defense, and he was trying to defend both himself and his daughter was there. That could have been a factor, too, that he was trying to defend himself, and he went for the gun when the guy told him not to. But again, I characterize that as the defendant blaming the victim. Like, he almost makes you forget he walked in with an SKS assault rifle fully loaded and pointed at both of those folks.
Am I correct or incorrect? I thought, from memory, wasn't there more than one person involved in that robbery?
There were 3 people involved in this robbery. And when I, as a district attorney, evaluate those cases, there was 3 that were facing the death penalty. I waived the death penalty with the getaway driver. I waived the death penalty with the accomplice, and only sought the death penalty on the shooter himself, Daniel Garcia.
I see. And are those other 2 cases resolved? Did they get life in prison without parole? Did they take a plea bargain? The driver?
They are not resolved. They are still pending cases. But we won't be seeking the death penalty on them. We kind of went with a scale of culpability, who was the most guilty, so to speak, and we all felt the shooter was the most guilty, and the getaway driver does not have the criminal history the other people have. So we kind of look at a scale thing. And when I say we, people should understand that the DA ultimately has to make a decision on whether to seek the death penalty or not. There is a way now under law that we can waive the death penalty, and I do that several times too. In this case, because of his background, and the killing itself was just a horrific, senseless killing, we decided to seek the death penalty. And I do that, I staff that with my supervisors, our first assistant or others 3 supervisors, and we get together and kind of go over this stuff and see if the jury would answer the special questions the way we thought so. Now, of course, being the defense, I had no idea what his background was. That's their mitigation experts brought that up. They had a mitigation expert and a psychologist who talked about his background. I only knew about his criminal background, not all that other stuff.
Now, by the two defense attorneys, I think, was Mr. Eric Perkins and
Hector Rene Gonzalez.
They're court appointed.
They are.
Okay. And were the experts court appointed as well?
They were. They're actually the defense lawyers go to the judge in the ex parte hearing, which basically means without me being involved, and they get permission to hire these experts in the court pays.
No. Come on. They have to file a motion. They have to file a motion, and the judge has to approve it.
In the ex parte motion, I don't get to play a part in that at all.
In other words, you don't get to state. I oppose I oppose the right for these for the defense to have these two experts regarding the psychologist experts.
I'm not allowed to do that. What happens is the defense lawyers can do it because, as you well know, Mark, the state has to reveal it's all this evidence to defense. The defense doesn't have to reveal any of the evidence to me. In fact, I did not see the reports of these two experts till the day they testified.
Is that right?
Mm-hmm.
So, as you're stating, now there's a new act called the Michael Morton Act, and I believe it's Texas Code of Criminal Procedure 39.14, which basically puts the burden on the prosecution to produce all of this evidence, right?
All of the evidence, yes.
And obviously before it was more subject to debate and emotions in the court. And my reading of the Michael Morton, he was actually my brief reading on him. Mm-hmm. He was actually a criminal defendant that was falsely convicted of capital murder of his wife, and supposedly evidence in, was it Williamson County?
Williamson County,
Williamson
correct.
County was withheld, and therefore which I was kind of surprised, in all honesty, that I assume it's a Republican-controlled
it is.
State...
county.
Pardon me?
County.
Yes. Was... That actually this act passed and that would give so much favor to the defense. I was kind of very much surprised. And what do you think of the Michael Morton Act?
Well, first of all, let's talk about a little history. Texas prosecutors have been given discovery to defense lawyers for many years. In fact, you know that in Oasis County.
And I was going to say for you, when I used to hear complaints about Carlos Valdez, mm-hmm. I used to say, look, we could do far worse, because we did have open discovery under Grant Jones, under Carlos Valdez, and under you. I mean, pretty much open. I mean, obviously there was always some room for some disagreement. For example, in the Hannah Overton case, supposedly that's why the Hannah Overton case was overturned. Is that right? Because there was some indication that some evidence wasn't provided to the defense. That's not where. There was
no finding in that. It was overturned for ineffective assistance of counsel. Her 5 or 6 or 7 lawyers she had were deemed ineffective, and it was reversed for that. There was allegations the state had not turned over some evidence of the reports of the contents of the child's stomach, but that turned out to be not true because the medical examiner had issued a report on that, and the defense had a copy of that because they questioned him at a deposition, the medical examiner. So that was not found to be true. That case was overturned because of ineffective assistance counsel. Now
let's go back so the audience knows who might be watching it on YouTube. Hannah Overton was a woman who was convicted of the capital murder, I believe, of a foster child because she'd given this foster child, she said it was for discipline, red pepper, and the child died under her care. And and I don't remember. I think the death, the defense is that the child had an eating disorder and got to the red pepper themselves, and that caused the death. Is that the case in a nutshell?
Most of that is correct. What happened is essentially during a trial, that was not the defense. Defense was she had not given any to him at all, that he had taken it all himself.
Right.
And it was actually a Cajun pepper thing that was used, and the child died of actually a salt overdose. But yeah, she was convicted of capital murder. The death penalty had been waived in that case by the previous administration, Carlos Valdez. I didn't really have anything to do with that case. Somebody else tried it for our office, but it was reversed for ineffective assistance of counsel.
Well, let me talk about that just for a second. And
Sure.
I interrupted you, that ineffective assistance of counsel. I will say this. I think that my opinion, which I try to keep to a minimum, but I think the ineffective assistance of counsel, the only way a lot of times now you could have a case reversed is if you prove your counsel was ineffective, pretty much now. And which I think is the ultimate hypocrisy and is making it more difficult to practice criminal law. In other words, the judge can't do anything wrong. This oftentimes political figure, they're perfect. They can't make a mistake on the ruling. The prosecution, which we know, for example, in that case in Williamson County, that DA actually who prosecuted Michael Morton actually was found eventually to have some criminal volition. He can't do anything wrong. Only the criminal defense lawyer can do something wrong to have a case overturned. I've got to say that I found that very objectionable.
Well, it's also tough too, and I'll give you a good example. Eric Perkins, one of my opponents in this last case, Eric Perkins and Hector Rene Gonzalez did a very capable job of representing their defendant, Daniel Garcia. But in the case that Eric Perkins had tried before this one, Brendan Gaitan, he was accused of ineffective assistance of counsel. I mean, it's very hard to practice as a criminal defense lawyer when another criminal defense lawyer comes and says, well, you were ineffective because you lost this case, or you did that stuff.
And the other thing is whenever you lose a case that goes to trial, in order for them to win on appeal, they have to say, basically, that it's ineffective assistance of counsel.
That is usually a point that the new lawyer comes and brings up against a lawyer who worked very hard to try that case.
And it's worse, I don't know if you know this, in the federal system now, they tell them, the only thing you could bring up on, if you plead guilty, the only thing you could bring up on appeal is ineffective assistance of counsel.
Is that right?
Yes, they do. So I think it's very low, and I think it's designed so people get actually less effective assistance of counsel, because more and more, I think it makes it harder, more burdensome for the defense attorney. But
there's no doubt, and defense attorneys have confessed to me that they have to cover themselves sometimes for a motion retrial, for an attack of ineffective assistance on appeal, and years down the line on a writ of habeas corpus that comes in, a post-conviction writ, they'll come in there accusing somebody 20 years before of not doing something. So yeah, you have to make sure you covered yourself well in court and covered all the bases and done your correct representation.
So on the Hannah Overton case, that case was actually overturned. I believe you, for ineffective assistance of counsel, and then you decide not to prosecute.
Yes.
Now, my feelings, even though, again, I don't know these cases. A lot of times I read about them years after the fact, and sometimes for the shows I try to read something. I did tell somebody that I was surprised that was involved in that case. And the reason I was surprised, I said, you mean they couldn't get her for criminal negligence? They couldn't try her for some lesser included offense, criminal negligence or something? I mean, if you went all the way and you tried it as a capital murder case originally, you couldn't get it for some misdemeanor? Why was a decision made just drop the case and not try to prosecute a Hannah Overton for some lesser case?
Well, some of the stuff I can reveal and some stuff I can't, but this is what I can tell you. When that case was reversed, I was out of town at a seminar and they told me, well, it got reversed. And of course, the first thing I want to do is read the opinion. Why did it get reversed? Was it something we did wrong? Was it some piece of evidence that failed? And it turned out it was a defense lawyer's inability to represent her competently, apparently, is what the court said. There were some allegations about prosecutor misconduct in there, but they never reached those in the decision. So I had to come back and look at it, and they said, are you going to try this again? And I said, well, sure, because they're saying there's no error in what the state did in the trial, and there's no error in what the evidence was. So I said, I was pretty confident we'd try it again. Well, then we came in there and we had many, many negotiations with the defense attorneys who were trying to get a lesser included offense, trying to get something out, trying to get us to dismiss
time
cases.
served, criminal negligence, time served, something like
Which
this,
was typical, and I'm not blaming them. I'm just saying
No,
that's kind of what
that's
happens.
sport.
That's what their job is to do. And they asked me, I remember specifically, we had a meeting with them and they said, would you go back and review some of the evidence and talk to a couple of expert witnesses who testified? Because I don't think they're going to say the same thing they said last time. And I said, what do you mean? And they said, well, such and such said this and that. I think they're not going to say that this time. And such said that. And I'm going like, okay. So they left the office and I talked to my prosecutor who was assigned to the case. And I said, we need to bring these doctors in and talk to them, these expert witnesses, and find out what they're going to say. And so we talked to them. And this was, 7 years after the trial. And I said, have you, the defense lawyer is telling me you're going to say this and that and instead of this. And they said, well, my view is this. And they kept saying, we don't think she did it intentionally. We don't think she did it intentionally. And of course, that's the big key on there, what your mens rea or what your mind state is. So after talking to both of the doctors and stuff and hearing what they were going to say, I felt that we did not have enough to go on the capital murder case. And if we had gone forward, these doctors would have basically said something different than kind of what they had said before. And when I say different, I don't mislead. I don't mean to mislead you. Say they changed their opinion completely. They were going mostly about the intent. So with them saying we don't think she did it intentionally, that put a big hole in our case. So when we were talking to the defense lawyers, and we thought about pleading it out to lesser included, something like criminally negligent homicide. I think the other one was voluntary manslaughter, involuntary manslaughter, stuff like that. Well, then when I was talking to my prosecutor that was in charge of the case, the problem with those is she had already served 7 years. So if you plead them out to a misdemeanor, it would have been worthless to plead her out to that because she had already served her time on almost every lesser included we have. Plus, the defense said they wouldn't plead to a lesser included offense. So it would put us in a catch-22. Why would we go back and try a case to get a lesser sentence where she had already served that time? So it was kind of a
I thought you guys liked to. I thought the prosecution often liked to get a conviction, even if it's just for.
That's
if
true.
Just for form that
that's true in many cases. Say, for example, you have a person that's charged with aggravated robbery, and you may have a hard time proving the aggravated part of the robbery, and so you plead it out to a lesser included of robbery. We do that a lot sometimes, and sure to get a conviction. But in this case, any lesser in conviction would have equaled less than what she had already served. I mean, if we did criminally negligent homicide, what would that have been? A year in jail. She had already served 7 years in jail.
Right.
So there was no point to getting that. So, and I will tell you, it was a very, very tough decision because, and I don't want to say politics involved, but the public perception is, there was half the people out there saying Hannah Overton should be let free, she didn't do anything wrong. And there was half the people saying, yes, she did something wrong.
They had quite an effective PR campaign that I think may have been professionally orchestrated.
It was well orchestrated, but I can't make a decision based on that. I didn't make a decision based on what her fans wanted. I couldn't make a decision on people said, she's guilty as heck, you need to try again. I had to make a decision what the facts and what the experts were going to say. And I had to make that decision and my decision alone. And that's what, I don't want to sound corny about it, but when you have a district attorney, with my experience, 29 years experience, this isn't something, first time I've had to make a tough call. And you make a decision based on not what the people want, not what the people say, not what this camp says, that what the group says. You make it on the evidence and facts. And that's what I felt I had to do in this case.
You bring up this deal about expert. You mentioned expert testimony.
Mm-hmm.
And, I've done, civil law and criminal law extensively. Mm-hmm. And I don't know how to ask this question. I guess I'll make an editorial comment. Boy, these experts are something sometimes. Sometimes they'll take the stand. You do not know what they're going to say, even if they're your own witnesses. Sometimes I don't know. I don't know now. I don't know if you're very well of the Dahlberg versus Merrill standards.
Sure, I've used that, and I had to use it to prove up witnesses. But the expert testimony is kind of the wild card in a lot of cases, whether it's a police officer who tries to testify as an expert wherein the defense says he's not qualified But I'm kind of, what can I say? I guess I'm saying I'm oftentimes personally disappointed in what I think of or see as the ethics of the experts.
changing testimony or whatever.
Well, there's no doubt, and,
You know.
and again, I don't want to say they changed their testimony. What I want to say is they thought it wasn't capital murder. They thought she had done it. They thought
That wasn't even their decision. That wasn't even their decision.
It's
to
the
make.
jury's decision. You're right. But that's what they were going to testify to that because one of them essentially, and again I don't want to go into specifics, but let's just say they were going to say that they didn't think it was intentional, and that would have cut out our capital murder stuff. But going back to expert witnesses, it goes both ways, both sides. Last week when I had this capital murder case, they hired a psychologist to say what a bad childhood he had, what a bad upbringing he'd had. He had a low IQ, and my counter was, there's a lot of people that were in special ed in school, and they don't go out and kill people. There's a lot of people who grew up without a mother or father or in a bad neighborhood, and they don't go out and kill people. So, when I hear witnesses getting paid, $200 an hour to testify that to help them, that kind of upsets me too, because a lot of these people are paid to espouse an opinion of their side. There's no doubt about it.
He did have a low IQ.
Yeah. Well, the funny thing is, when they tested him in, I think, TDC, he had been to prison before. They tested him at a 76, and the 70 is kind of the borderline.
No,
although they kept saying this stuff. Well, and then the expert they hired to test him again, the one that tested him recently, 82. He didn't have that low of an IQ. He had, 70 being the borderline, he had 82. And I'm telling you, Mark, it's one of these things. It's perception. You probably went to school with people with lower IQ, and they go on to have jobs and have families and stuff.
It's a very complicated issue.
It's a complicated issue,
but some of them have good human skills, and they can do very well. Good work.
Some people can only do manual skills and not intellectual level skills. But the point is, there's a lot of people that go out there with bad backgrounds and don't go out and commit 10 felonies, 10 crimes, and go to prison at the ripe old age of 26.
But let me ask you this question, and this is kind of off point. You may not feel like you should even state, but it's also true. When you get someone who usually commits murder like that, the largest percent of the time is they are going to have been abused. They are going to be mistreated, right? You're not usually going to find one from a good home where the family unit was intact. They took their kids to church, right?
There's no doubt about that.
Right?
I mean, you don't have people who, but once in a while you'll have a person from an affluent family that go out and kill somebody or something like that. But in other words, but that goes back to what you were asking me. Why do you think the jury gave him a life sentence? I think they looked at these mitigating circumstances and felt this had an effect on his life, and that's probably why they gave him a life sentence instead of a death sentence. I can guess that because the defense did a very capable job of showing that, his bad background, his history and stuff. And that's their job to do.
So I think I had perhaps interrupted you. So you think the Michael Morton Act is a good act?
Yeah, well, put it this way. We've been, at least in Nueces County, we've been following open discovery for years and years and years. A couple of things historically you should know about the case in Williamson County. That office did not have an open file policy. That office had a closed file policy. Defense lawyers, this is 25 years ago or more when this happened.
What is Williamson County? What city is that? I forgot.
It's actually Georgetown.
Okay.
Georgetown is the county seat. It's right above Austin. It's about 20, 30 minutes above Austin. Really nice little community, about 50, 60,000 people. It has a big elderly retirement place called Sun City. A lot of people go there.
And as an aside, we've had counties closer. Jackson, I think it's Jackson County, under Bobby Bell, does not, who I believe is still the district attorney, does not have an open file policy. So we've had closer counties that did not have an open file policy. In other words, to get the evidence, you have to file a big motion and go through quite a bit of work. So it's not uncommon.
And it's never been that way. With Grant Jones, Carlos Valdez, myself, defense lawyers asked for it, we give it to them. What it basically did was codified it, made it part of the law instead of just kind of an ethical thing and a routine practice to do. Because most of the time, defense lawyers would file a motion for continuance and we'd say, here, what do you want? We'll give it to you and everything. So that law changed and made it law pretty much that people couldn't have closed file policies. Because that was a big problem in Williamson County 25 years ago. What happened with the DA at the time, Ken Anderson, did not give police reports, witness statements, test results to the defense until the person testified on the stand.
Right.
And you as a defense lawyer knows that's kind of hard to prepare your case when you don't know what the witness is going to say and what the police officer is going to say. Specifically in that case, I don't know if you know the facts of that case, but it was a woman was found murdered, and they looked at the husband as being the murderer who was away at work. Well, supposedly during the the conversations with witnesses, they had I want to say 4 or 5 year old son there. And when the police talked to him, and it's very hard to get kids that young to be able to be qualified as testify in court as competent. Well, this kid apparently told one of the officers, a monster killed mama. It wasn't daddy, it was a monster that killed him. Well, you take that from a 4-year-old, and what does that mean? It kind of means the kid might be making things up, fantasizing it was a monster, but he also says it wasn't dad, it was a monster. So is that exculpatory, or is that inculpatory, or is it just something you can't believe either way? Well, the problem was the prosecutor never turned that statement over, so nobody could determine that. If you were the defense lawyer on that, you might say, well, we know the kid's fantasizing, but he says it wasn't dad. I'm with you, because is that important or not?
Well,
but here's the second thing that happened.
Unless it was a tape-recorded interview with the child, then
it was a kid, and bless his heart, he didn't know. Okay, right. He said this stuff, but that did not get turned over to the defense. The second and more critical thing was when they were doing a canvass of the neighborhood, a search of the neighborhood. Well, I'm sorry, one other thing. A statement came out from one of the neighbors that said there was a green van parked in the alley behind the house that day. Nobody knew who this green van belonged to, but it could have been the so-called suspects. But that was not turned over to the defense. So they didn't know about this mysterious green van. Again, did that prove the husband did it or not?
I want to make an editorial comment too. Even though I've had a lot of I've had disputes with you probably, and there's just so much evidence. There's just so much, a ton of it, to turn it all over, or to miss a small piece of evidence that might be important later would be very easy.
It is easy, and we've had situations like that. But in this case, again, back in Williamson County, specifically, they knew about the green van but didn't tell the defense. And the last piece of key evidence was when they canvassed the neighborhood, they found a bloody rag or bandana in a field behind the house. You know how the police officers scan and search the grounds for any kind of footprints or any kind of evidence? Mm-hmm. They found this rag that could have had blood on it. They collected it, but didn't do anything with it. They didn't test it all and didn't tell the defense anything about it. So later on, 25 years later, when his appellate lawyers came in and they said, we want to test this blood because maybe it's the killer's blood. Maybe he got cut or hurt after the killing. Well, the prosecutor who had tried the case had gone on to become a judge, and his first assistant had become the DA. That DA, for like 3 or 4 years, refused to let the defense test that rag or that bandana that was found in the field. And some people were very upset about that, like he was stonewalling the investigation. And of course, nobody knew if it was going to be good or bad for the defense. Turns out, after 3, 4, maybe 5 years of him refusing to let him test this bandana, an upper court told him, no, you got to test this. So it was tested, and it came back to the blood, not of the killer, the alleged killer of the husband. It came back from the DNA database of another criminal who was actually on trial for murder in another community far away from Georgetown. So they went and checked that out, and it turned out he was the one who killed him. This other person who was standing trial for murder in another county, it was his blood over there. So they tied him into the crime. That's what basically freed Michael Morton, because after 25 years, they now had concrete evidence that somebody else's blood was there at the scene or around the scene.
But I haven't read that much about it. I almost thought, by my brief reading about it, I go, of course, being a minor conspiratorialist, why would they pick this man? If I don't think he had a criminal record or anything.
The story was, and you probably know this more than most folks, officers or investigators are always trained to look at the family members and the friends first.
Because usually they're right.
Because usually murders,
Right.
we think it's stranger on stranger, and most of the times it's somebody the victim knew. So they didn't have any other suspects. He's the best suspect he had. Now the stories I've heard is that it was an unsolved crime. The prosecutor, the DA back then, Ken Anderson and the sheriff would kind of have coffee together and kind of work over this cold case
Of course.
and try to come up with some theories and stuff. And their theories kind of pointed to him. And so he was convicted. And it turns out wrongfully. And I will tell you this, and just let me editorialize for a second here. Every prosecutor in Texas hates that happened. Most prosecutors, and you've probably known a lot in your almost 30 years of practice, trying to do their job and trying to do it ethically and a good job. Most prosecutors are ashamed of what happened back then. But we want to tell you that's a pretty isolated incident.
Well, let me say something else that I think. If you go to some of the smaller towns, and assuming the district attorney tries that case, and he's from that community, which they usually are in these smaller towns, and they go back there, and he knows everybody, good luck.
It's tough.
Good luck. I mean, it's not like, Mark Skurka, born and raised in Corpus Christi, 3,000 people in Corpus Christi. That town is pretty much oftentimes controlled by that sheriff and by the district attorney, and what they say goes.
And that could have happened in this case. I can't tell. And, people ask me what happens in other counties. I really can't tell. I can only speak for our county.
Right.
And I can tell you that we have open discovery. We've had open discovery. When Michael Morton came along, we didn't have to change a lot of stuff. The only thing we did, and we did this before Michael Morton even passed, we made it electronic discovery. In other words, what happened in the old days, you probably remember you'd have to come to the DA's office and try to get a copy of the papers. Well, now what we do is we have this thing called Dropbox. When the officers give us their reports and the stuff, we scan that into the system, and then we send it back to the defense when they request the stuff, all the things that we've scanned from the police department, and that's how we give it to them. So we try to go paperless a little bit to try to save some money. But it's like you said, I mean, we process 12, 15,000 cases a year. Sometimes things can get messed up.
I know on the big cases, like I said, I've had disputes with your office and with other offices about evidence, but I have to say that there were a couple issues that were, there was some degree, there were 3 defense attorneys that were complaining about evidence that you failed to turn over in some sort of on one of these
cases
channels. One of these channels had like a story, and they had 3 defense attorneys. And I thought to myself, at least on one of them, I said, well, they have to. One of the defense attorneys was complaining that you had destroyed a disc and hadn't told them about it. I thought that was a little bit of a reach. I said, well, they didn't have the disc. Do you have to tell them about everything that's thrown? Unless that you threw it, unless it was destroyed on purpose. I didn't think it was a major thing, and then it seemed like it was that major of evidence.
There were 3 examples I would point out. And what you're talking about is a case where some people were found in a van that supposedly had mistreated their kids. They were starving. They were having to go to the bathroom out there. They were using meth in front of the children. And apparently there was I think it's called a hard drive or a disc, that supposedly they had some family pictures on it. Well, the police department picked that up when they searched the van. They looked at it and they couldn't find any incriminating evidence in it. So they just kind of put it aside, and apparently that got destroyed or lost later on. And there was no proof that it was either helpful or hurtful. But the officers or the district attorney, assistant district attorney who was doing the case, had either lost it or it crashed or something like that, and they couldn't recover it after they had looked at it. Because they looked at it and they didn't see any criminal acts on it, so they didn't do anything with it. That was one they complained about.
I think the defense argument was that it showed them happy and healthy together.
And it might have been, it could have been family pictures that happened 2 years, 3 years before. It didn't have anything related to the offense. The other one was, it happened it was a 911 call that had happened that we didn't know that it existed. And we were in trial, and the detective was on the stand saying, well, yeah, on the 911 call. And we all said, what 911 call? The defense had never got it. We had never got it. The officer admitted on the stand that he had messed up and he had tried to copy the other tapes onto the diskette, and he had not copied the 911 call along with the photos and the videos of the everything. So the defense lawyer said, well, we want a mistrial. They're holding back evidence and everything. And we're saying we didn't even know that evidence existed. The police officers didn't know. So the judge, who was, I think, very wise in that case, said, well, let's stop and hear what this 911 call said. Is it going to help the defense? Is it going to hurt the defense? Is it going to help the state? So the officer went back to the station and retrieved the 911 call, brought it in, played it for the judge, and all it was the victim's mother saying 911, 911, what is your emergency? And the lady said, my daughter's been assaulted. You need to send help to such and such address. That was it. So once it was played in court, it was seen that it wasn't helpful or hurtful to the defense. It was just a small part, and the case went on. But in that case, and I don't want to throw the cops under the bus, but we rely on what they give us. If they tell us they've given us everything, we believe that. In fact, when I was DA, since I became DA, I make the officers sign a form certifying that they have given us all their evidence and that they will continue to supplement it. But when you file, 12, 15,000 cases, sometimes maybe something doesn't get done. And we're all working to try to solve that problem. In fact, I've tried to get some new electronic programs, and I don't know much about software or something like that, but supposedly there's some software out there that tracks all the evidence given by the police department and makes it accessible both to the state and the defense. So we don't have this wait. Each side has equal access to the evidence. I've been trying to get that going. In fact, we have a demonstration coming in front of the Commissioner's Court, defense lawyers, and judges to see if we can get a program like that going. Right now, we have a pretty good program. Everything the police officers give to us, we scan it and send it to defense lawyers. But then it's been the occasion, just like that 911 call, that something comes in later and we don't have it. Now, the answer to that is what happened in the 911 call. Stop the trial if the defense needs more time to prepare, if something comes in late, because sometimes we get stuff late and we turn over to the defense and the defense says, well, we just got this yesterday. And we say, that's because we just got it yesterday. Give them a time continuance, and you've probably done that before. If you're not ready, you get some new piece of evidence, you can ask the court for continuance. But the whole point is we want to give the defense everything that we have, and we do that as best as we can. And I think we're pretty successful about it.
I didn't know if there may have been a third accusation on
the third
story,
one.
if you wanted to discuss it or not.
You want me to tell you the third one? The third one was a lady ran over her husband in a bar parking lot because she caught him having drinks with some other ladies. This was out in Cow Allen area, and she waited for him to get out of the place and walked to his truck. And as she walked to his truck, she ran over him with her car and killed him. The charge was murder on that case. It turned out she got found guilty of voluntary manslaughter, but the charge was murder. And our prosecutor had been sent a DNA report from the officer in charge of the case. It had been emailed to the prosecutor, and the DNA report was a negative DNA report. In other words, what they had done was swab the bumper of her car to see if there was any skin cells or anything on there, or tissue, or blood or anything like that, and it turned out it was negative. The defense lawyer had never asked for discovery on that, had never filed anything or asked anything. And that's another key point. Michael Morton Act is triggered by the defense asking for this stuff. Once they ask for it, it triggers our response and do it. He had never asked for anything till the Friday before the trial. So our prosecutor apparently forgot that there was this negative DNA report, and she found it at the last minute with the investigator testifying. So we brought him over, and it was a negative report, but she had already confessed that she had run over the guy. So it wasn't an issue. And, DNA is for identity. Who did it?
That's right. So that issue wasn't even.
It wasn't even
a triable issue, really. It was being tried whether it was accidental or intentional.
That's exactly right. It wasn't a material issue. I mean, should it have been turned over? Sure. Should our person have turned over? Sure.
Why did why do you think that TV station brought that story out? Was there a motive? Was that against you? Was that a personal attack against you for political reasons? Someone told me that some of those defense attorneys know someone who's going to run for DA or something, and that's why, and that was a political story. Is that right?
I don't know. That's up to them. All I know is we had those incidents happen through no fault of our own, except for the one. I mean, the one, the disc crashed. The second one, the 911 call was never given to us. And the third one, our person messed up in that. There's no doubt. She had not turned over that negative DNA report. But I think there's how can you say this? No intentional part on our office or our motive to hide things. You know what I tell my prosecutor when they come in? Give them everything. Just give them everything. See, that way the prosecutors don't cherry pick. Well, I'll give them this piece of paper, but not that piece of paper. I'll give them this piece of paper, but not that document. If you turn over everything, you can't be accused of holding anything back. But it's just like in Texas, that one with Williamson County that started the Michael Morton Act. All those facts took place 25 years ago. I mean, I hope to think that we're a lot better than we were 25 years ago, and lawyers and prosecutors are trying to be as ethical as they can. Many times our prosecutors go to court and they say, you want to look at my file before we start? Here it is. Take a look and do what you want. We have nothing to hide. We don't have no reason to hide anything.
Changing subjects very quickly, I had heard talking about, you said you'd agree to talk about it, and I'd wondered about bringing it up. I've heard rumors and I've heard complaints from assistant district attorneys that state that they don't have enough discretion in deciding what to do, and that everything has to it's either proceduralized. I can't remember if they say it's proceduralized. Well, so much for a first degree felony, so much for a second degree, or everything is runs through you regarding plea bargain offers. How would you respond to that? I don't have much personal knowledge other than what I heard from third-hand sources.
Well, it's flat out not accurate. What happens is there's no way I could micromanage 12, 15,000 cases a year. I guarantee you. I look at over some of the felony cases, but there's no way I could look over that. I have faith in my prosecutors and my supervisors to do that. So there's no way that that all cases have to come through me. What happens sometimes is we have some general rules that we expect our prosecutors to follow. Number one, if a person's been to prison before, they're probably going to go to prison again on their subsequent case. They're not going to get probation. If a person has gotten a DWI, a felony DWI, the third time DWI, generally speaking, our plea bargain offer is prison or a lockdown facility where they can get rehab, which is SATF or SAFPF. But, one of our policies is if you did, 20 days on your last jail sentence and you get a new one, it's going to be 30 days. It's going to be more. Those are generalizations that we all accept as prosecutors and try to do. Are there exceptions? Sure. They'll come to me and say, look, you have this guy as a habitual felony offender, meaning the minimum is 25 years to life. But we have some situations, some facts have come up that maybe we should give them under 25. And they come to us and talk about that. But no, they have plenty of discretion to do what they want on those cases. Do we review those? Sure, because that's supervision. Do we tell them, no, you have to do this, you can't do this unless we tell you? No, we don't do that at all. In fact, I write in very, very, very few files. I wager that if you'd go and look at 200 files, 250 files, you'd probably see me writing one of them, two of them. It just doesn't happen that way.
One of the subjects that you wanted to, when I asked you, Facebooked you or whatever, and said we want to talk about it, one of the things you said was about domestic violence.
Terrible problem in Nueces County. What I want to talk about domestic violence is we have too much of it in Nueces County. We just had another one the other day. Probably more than half of our homicides in the last year have been attributed to domestic violence. We have all kinds of misdemeanor and felony cases dealing with domestic violence. The problem we have is not the laws, not the judges or the juries or the prosecutors, defense lawyers. The problem is we have to get out of this mindset in our community, in our country, that it's okay to beat up women. Unfortunately, it's a learned behavior. Unfortunately, it's a cycle of violence that continues all the time. And my office and my victim assistants and prosecutors are dedicated to trying to break that up. Do you know that a couple of years ago, several years ago, a lot of cases were getting dismissed because the woman would not show up to court to testify against the perpetrator because it's a loved one, a family member, a boyfriend, a husband. So we had a hard time getting these people to cooperate. The police department has a hard time getting these people to cooperate. Working with the women's shelter, we got together and decided to have a domestic violence summit last December 1st, where we had all kinds of people from the community come in to talk about the resources that we have available to fight domestic violence, to try to change that mindset. That starts with everybody, each family, each community, each church, each school, each family. We've got to do something to break the cycle. I've been a prosecutor for 29 years, Mark. We have murders. It's going to happen that way. But it's very sad to have some woman who's just been beat up over and over again and finally ends up in death. By the time they get to my office, it's too late. We need to do something to stop it as a community from happening in the first place.
Well, I tried 2 cases last year. They were both
Domestic violence?
yes, both of them, and one won, lost one, right? The one I thought I would have won, I won. One I thought I was going to lose, I was going to lose. I'll tell you something for editorial comment. A lot of those guys are just bullies. They're not beating up their wife. They'll beat up anybody. They'll push around anybody.
Mhm.
That's their psyche. It's not necessarily oriented against the woman. That's who's around, and with a bully mentality, sometimes they're weaker.
And it's power and control over that
Right.
person.
So, I mean, I don't know that it's the male-female issue that everybody puts forth. I mean, I'll just say this. And because of my age and doing this so long, it's very seldom that I lose my temper, like, to anybody, including a criminal defendant. But those guys, you're not going to bully me, So they get you to lose your temper. So that's one of the issues. Secondly, I was talking to an assistant district attorney in a small town here, somewhere around here that I practice, and he basically says, look, what I've said, what are you going to do? Like you say, what is the percentage of these women that don't want to come testify? And you have some sort of crackerjack investigator. I don't know who's doing it. He's tracking these women down like nobody's business and getting them to come to trial. I don't know who this person is, but they've been doing an extraordinary job because,
You know what happened was about 3 years ago, I asked commissioners for another investigator because we didn't have an investigator for our misdemeanor courts. You go to any other good-sized jurisdiction, they have tons of investigators. We had 2. I got the commissioner to hire a 3rd one, mostly for that reason, to help find these women to come testify. And what would happen is a lot of times it would be a game of chicken on Monday morning. Defense lawyers would hope the person wouldn't show up. The person would show up, they'd plead guilty. And one thing that should be pointed out, Mark, and you might know this, we're not trying to send every one of these guys to prison for 20 years. What we're trying to do is sometimes give them probation so they can get alcohol treatment, drug treatment, anger management, the BIP program, Batters Intervention Prevention Program. There's a lot of things that are out there to get them to unlearn the behavior they've had, to stop the violence from happening again and again and again.
But I had thought, and I didn't really read lengthy articles about the domestic violence from your office and what are we going to do. I don't think the DA is going to do anything. I think they could pass more laws. It's not going to solve anything.
Well, that's what I told you. I don't think it's in the hands of the DA. By the time it comes to me, it's too late.
Well, and then
our
say
community
it's got to stop. How are you going to stop it? How's the legislature going to stop it? I don't know. I don't even now. Has it gotten worse than what it was when we were kids? I don't know.
It's hard to judge it because a lot of it used to be unreported when we were younger.
But
I'll tell you, I can't stop it.
I don't know.
I think
they act like the media almost blames you. I think is that right? What are we going to do? Well, I don't know. What are you going to do? Put a policeman in everybody's house? Maybe we should put cameras like I have in my office and every.
I don't
even understand the issue.
We have to change our community's values and thoughts about domestic violence. It starts in the home, but we could train people in schools with the help of the churches, with our community to stand up and say, we're not going to take that along anymore.
I don't know. That's like the drug problem. Oh, the drugs. Well, I don't know what you're going to do. They want to take them. These people are involved in these relationships. Obviously, the ones that turn physical are the ones that you're involved in. I mean, you probably dated women. Sometimes you can be involved with a woman that could be very abusive.
We've had it, and it goes both ways. I'm guessing 10% of our cases are men who are being abused by women or attacked by women. It's not a male against female. It's sometimes female against male. But the problem is we've got to do something to change our mindset in the community. This is what happened. Let me give you an example. Do you know Abel Alonzo, my friend who's in the wheelchair, is a political activist that goes around town and takes up stands? Well, what happened is he came to the domestic violence thing and he listened to a victim of domestic violence and he learned about the cycle of violence that is perpetrated on the same family over and over again. He said, when I was a kid, my dad beat my mom. My uncles beat their aunts. My grandpa beat my grandma. I thought that's what guys do.
Well,
people
that's all
have
you
to-
see. That's all you know.
That's because
that's how
the,
you're raised.
that's the cycle of
Or
violence.
somebody says, or you yell at them, whatever. That's what you do.
There's mental abuse as well as physical abuse.
That's what you know.
But see, that's what we got to change and tell them there is another way. You don't have to do it that way. You can do another way. It's just like some people, maybe they grew up in a home of an alcoholic and they grew up and said, I'm not going to be that way when I grow
I think
up.
is indicated in the Homer Simpson, in the O.J. Simpson trial.
Yeah.
In the O.J. Simpson trial, I think there was an acknowledgement, though, that merely because a man is losing his temper with his wife and hitting her, it doesn't mean that necessarily that's how certain people live. Maybe certain subcultures, certain ethnic groups, maybe certain economic groups. That's just how they live, and it won't necessarily escalate into murder. I don't know. I'm not saying that's true, by the way. I'm just saying, throwing that out there.
But let's put it this way, Mark. Do you really think that most of the cases that come to my office are the first time he's hit her? I don't think so. Most of the time when we talk to women, they say, has he ever hit you again? Yes. And maybe they finally reached their breaking point and report it. Maybe it started with a slap, maybe then came a punch, then the next time it was something worse and they finally reported. I don't think we have a lot of first-time offenders out there. I think we have something, and just like these cases that end up in murder, sometimes it's not the first time they've heard them. It's a series of things that go on and on. However, there are times when it is the first time they've done something.
But isn't it just as likely that you have to end the cycle of violence through the woman? Because we heard for years, the women got to be able to work. So now they go to work. And now they have the women's shelter. And now, what are you going to do? Okay, now you can work. Now you may get child support. Now you got the women's shelter. Well, it's kind of like the cone. Have you ever heard the sound of one hand clapping? No, it takes two hands to clap.
Yeah, but the simple thing is there's no excuse to hit a woman. Never. There's just simply not ever an excuse to hit a woman.
I'm not disagreeing with that, but there's no excuse to hit a woman. Maybe there's no excuse to hit a kid. There's no excuse for a woman to hit a man. There's no. I don't know that. I don't know that's not necessarily going to solve the problem, and I think that the women need to take a certain amount of responsibility for going back to these men.
Well, that's a whole psychological thing because a lot of women, and that's what most people think. Why aren't the women leaving? Why don't they just stay away? And we could talk forever on that.
There's a certain naivety in everything in the media, regarding human relationships. Let's be very frank. Okay, this woman, maybe it's the only man she ever had sex with. Maybe she has children with this man. Maybe she, and you're saying, well, leave him. Well, that's easy to say.
For us, on
on
the sidelines, but there's
but she's emotionally involved, economically involved. They've got children together, etc. Oh, okay, just do this. Well, so it is a complex problem, and you're trying to do something.
Here's what I'm trying to do. I'm trying to raise awareness in our community of the problem and admit there is a problem. I'm trying to educate people on what the problem is, how we can do it, and I'm asking the community to help out. I don't have all the answers. That's one reason we had that domestic violence summit, so people could come up with an idea. And it really all starts here with us. You, me, every group. Anything that we can do to prevent this would be great.
I wanted to thank Mr. Mark Skurka, District Attorney, for coming on in Oasis County. I guess he's going to be running again. And what year would that be?
Next year, 2016.
Next year. Well, good luck, and maybe your opponent will come on. Who knows? If you have an opponent. Thank you.
Thanks for having me, Mark.
Thank you. Good night.